Hi Cyber Class, this is Professor Opterbeck. I just want to catch up briefly with you in this little video. First of all, I want to say great work. Keep up the good work that you've been doing. We're nearing the end of this crazy semester and I really appreciate everything you're doing. This week and next week, we're looking at some really difficult material. So I do want to kind of just give you a little warning. Some of the material is difficult. We're looking at online child exploitation. This week and next week, we'll be looking at harassment, stalking, and other personal online crimes. And these are really difficult subjects, but they're very, very important for us to address. When I first started teaching cybersecurity law and policy as a standalone course 8 or 9 years ago, I had a number of New Jersey County prosecutors audit the course, and I put together some roundtables and some other things. And as you'll see, I actually had a hand in helping to shape the current New Jersey online child pornography statute. So this is an issue that's really important to me. It's an enormous problem, and it's very difficult for the law to address, but it's something we have to talk about. So in addition to kind of giving you that little heads up for this week, I want to give you just very briefly some supplemental material that relates to your discussion post. And you'll see a lot of the material we're talking about this week involves efforts to protect children online, and the difficulty of doing that in relation to the First Amendment. Now you'll see it's not difficult to say child pornography, distribution, possession, and so on, and creation of that material is a crime. That does not violate the calling that a crime does not violate the First Amendment. Child pornography is not protected speech. But when we go a step further and say we want to take other measures to try and protect children online, that's when it becomes really difficult. And one of the key places of that debate right now is what, if anything, Congress can do to put some responsibility on internet service providers and on social media providers to police some of this content, because that's the place where a lot of this content now gets distributed. And that, of course, runs headlong into First Amendment concerns, and it also runs headlong into one of the core policies of the open internet, which is Section 230 of the Communications Decency Act. And I'll show you that in just a minute. So let me first, I just want to really quickly show you a couple of things that Congress has done. This is the federal child pornography statute, and it's similar to many state statutes in the area. There's no question at all that this is perfectly constitutional. So, you know, transportation, shipment, receipt, distribution, and the kinds of things that you would define as obscene or pornography involving a child. One thing to note here, and you'll see this in the New Jersey statute as well, is that the age, it used to be a lower age, 15, some states 13, but the age is, in most states and in the federal law, is now simply the age of majority. Congress has enacted some statutes about misleading information on the internet, and these were really enacted in the aftermath of the COPPA saga that you're going to be looking at in the Supreme Court cases for this week. But this involves deceptive words or images, metadata, other things that try and divert traffic from minors and others to sites that are not appropriate for them. And I think, you know, as you read these cases, I think I pointed out in my original videos on the Supreme Court cases, but some of these early cases, I think the majority is a little bit naive about what the internet eventually became. But think about that a little as you look at this statute. Similar kind of thing, a misleading domain name, again, that is designed to misdirect somebody. These statutes in general are not going to be First Amendment or Section 230 problems because they're about doing something misleading. Here is the DMCA safe harbor. This was really important, and many internet, kind of open internet activists think this is the fundamentally most important piece of internet law and policy, which says that the ISP, the provider of a site on which users post information, is not treated as the publisher. So for purposes of defamation law, the ISP or the host is not on the hook. For purposes of child pornography law, likewise, in general, it's not the platform that is publishing. Because remember, publishing or distributing the material itself is a crime. And This is seen as really important because it does not treat websites like we treat, say, traditional newspapers. A newspaper is a publisher. A newspaper has an editorial responsibility to verify that its content is accurate and that its content is not defamatory and that it's not publishing materials that it shouldn't be publishing. Now, the DMCA also provides a safe harbor for providers that choose to use some kind of screen or some kind of filters or other technology or action to try and block this kind of content. And so, in the event that the site overblocks certain kinds of content, this statute would suggest that the site is not liable for that. And of course, Twitter and Facebook and the major reputable social media sites and YouTube do take steps to try and block certain kinds of content. Certainly violent or extremist content, they take some steps to try to block. Child pornography, they do try to block it. But that all at this point is really voluntary, contractual, and then backed up and protected by these safe harbors. Also, by the way, of course, having just come through this election, and whichever side of the aisle you find yourself on there, we have ongoing disputes and debates about what the social media sites are or not allowing through, and this provision is going to be relevant to those debates. So Congress, at least parts of Congress, has been trying to chip away in places at Section 230 of the CDA, and one of the places that Congress has tried to do that is with online sex trafficking. That is, with prostitution that is facilitated online. And that resulted in amendments to the sex trafficking statute relating to Section 230 called SESTA and FOSTA, and these were very controversial within the internet civil liberties community. So there's kind of a sense of Congress that sites have been reckless in allowing themselves to promote prostitution. In a lot of ways, this was sparked by sites like Craigslist that were facilitating prostitution, human trafficking. SESTA and FOSTA amend the CDA to say nothing in the CDA immunity shall be construed to impair or limit a charge under sex trafficking law. Well, what exactly does that mean? It's not entirely clear. Sex trafficking, of course, has an actus rea and a mens rea requirement, and the requirement is that there be an intent to engage in sex trafficking. And if the site itself has a specific intent to engage in that, it likely would not be protected by the Section 230 immunity anyway, because that's not just being a passive site that's intending to do something. So it raises a lot of questions about exactly what it means. SESTA and FOSTA also amend the federal sex trafficking statute. So you can see here in Section A of this portion of this part, to own, manage, operate an interactive computer service, an ISP, or a social media site, or so on, with the intent to promote or facilitate prostitution, constitutes a federal crime. Now, of course, there is a mens rea requirement here again. It is a question of intent, and that kind of specific intent may not fall, but by the site itself, may not fall under the Section 230 safe harbor anyway. But notice also that it's not just promoting, it's facilitating. So there is a question about what does it mean to operate a site with the intent to facilitate prostitution? Is it enough that you have red flag knowledge that you're operating a site like Craigslist and there is a lot of sex for sale, a lot of prostitution happening on that site, and you're making a lot of revenue off of it, but you're not specifically promoting it? And that raises a question that for some people is troublesome, other people is important. Section B of the same statute talks about a higher degree of penalty if there's 5 or more persons involved in this promoting or facilitating prostitution with that intent. Notice also, though, intent to promote or facilitate prostitution and act in reckless disregard, a lower degree of mens rea, that the conduct contributes to sex trafficking. And the federal sex trafficking involves essentially transporting people across state lines for sex. and also involves fraud or coercion, and also involves anyone under the age of 18 in interstate commerce. So you can see what this statute is trying to get at, and you can see how it's potentially more narrow depending on how you interpret intent, potentially broader depending on how you interpret facilitating. There is an affirmative defense. Of course, there are a few jurisdictions in the U.S., for example, in Nevada, where prostitution is legal, so it would not be a violation to use the internet to promote or facilitate legal prostitution in a state where it's legal. In no state is human trafficking against somebody's will or through force or coercion or involving a minor legal. I also want to point out the specific federal sex trafficking of children statute. And you can see here that it again involves interstate commerce because that's what federal criminal law has to do. You can see the kinds of acts that are involved. You can see that the mens rea is knowingly, and it includes just receiving some benefit, receiving some financial benefit from these kinds of acts knowingly. And there's this definition of what it means to participate in such a venture, knowingly assisting, supporting, or facilitating. So there's quite a bit of question about would this provision include a site like a Craigslist or some other social media site that, again, is not specifically intending to promote, but is still knowing that that activity happens and is receiving benefits from that activity. Does this put an affirmative duty, legal duty, on those sites to mitigate that, or does Section 230 come into play? I think those are some really interesting questions. So I wanted to give you some of that supplemental material, and again, I wanted to say, hang in there, keep doing good work. The material these next couple weeks can be a little bit rough, but it's really important and really vital to the question of what I think the broader concept of what security means in cyberspace. So I'll see you online. Oh, I also wanted to mention our final summit coming up next week. Have a couple great speakers already lined up. Have Mike Garrity from the New Jersey Cyber Information Center, is one of the chief cyber officers in New Jersey, and he's a really great guy and a friend of the law school, and I think you'll enjoy hearing from him. And Mary Hillenbrandt, who is a privacy and cybersecurity law partner at the Lowenstein firm. So we're looking forward to that, and I'll see you online.